Hello, guys, and welcome to another episode of our civil litigation mock trial course by the DECO Daniel School of Law. And on today's episode, we'll be talking about our draft for summary judgment under Order 13 of the Lagos Rules and Order 11 of the Abuja Rules. Now, it is important at this point to state that this is another very juicy area for law school. Do you understand? Very, very juicy area for law school to ask you to draft. That's number one. Number two, it is also important for you to note that there are certain documents. If you want your matter to be set aside for summary judgment, right? Under the Order 13 of the Lagos Rules and the Order 11 of the Abuja Rules, there are about 8 documents that you are supposed to submit before the courts. About 8 documents. One of those documents is an application for summary judgment. Do you understand? And it is this application that we are drafting. If you do not understand what I'm saying, it therefore means that you have not listened to the Module 6 class. Our Module 6 class, which has about 10 to 15 classes, where I explain summary judgment under Order 11 of the Abuja Rules and Order 13 of the Lagos Rules. Under our Module 6, I explain every single thing that you have to know there. If you do not understand what I'm saying now, please go and watch the video. This class is not to teach summary judgment. This class is to teach how to draft the application for summary judgment, the motion on notice for summary judgment, right? Under Order 13 of the Lagos Rules and Order 11 of the Abuja Rules. Do you understand that? Now, the first thing in all our applications is the heading of the court. For you to know where a matter is to be taken to, you must know the jurisdiction of the court. I have taught you jurisdiction under our Module 2, where we talked about court with civil jurisdiction. If you do not understand jurisdiction of courts very well and you need more clarity, please go and watch the Module 2 to get the clarity. So if you know the court that you want to go to, for example, in this case, we are going to the High Court if we are seeking for summary judgment of this nature. In the High Court of Lagos State, in the Lagos Judicial Division holding at Lagos. But if it is Abuja, in the High Court of the Federal Capital Territory, Abuja, in the Abuja Judicial Division holding at Abuja. Do you understand? The next thing that we then talk about is the suit number. That is another mark. The next thing is what? The suit number. After the suit number, what then are we talking about? Between the parties. When I was teaching you our class on interlocutory application, the draft for interlocutory application, you know that this is an interlocutory application, right? When I was teaching you our draft on interlocutory application, I told you that you are supposed to know that for every interlocutory application, motion on notice or motion ex parte, it is supposed to be claimant applicant or claimant respondent and defendant applicant or defendant respondent, depending on the person that is making the application before the court. If you don't put that in your parties clause, you have lost every single thing that you need to get from that parties clause, which is usually 1 or 2 marks in bar finals, and 1 or 2 marks, very, very important. Now, also, for you to know how to draft this parties clause very well, I have taught it very, very well in my parties class. So I expect that you are supposed to have read through and listened through my parties class, parties to a civil action, Module 3. Right? So you can see why certain topics came first. Jurisdiction came first because when you are drafting, you have to know the jurisdiction to take that matter to. Then parties came next because after your court, after suit number, no be between, you go talk the people where they come court now. Do you understand? So therefore, you have to know how to draft parties. Representative action, how do you draft? Person suing as executor, how do you draft? Unregistered association, how do you draft? A person suing as a child or lunatic, how do you draft? A person suing as business entity, how do you draft? What about if it is the government that is suing? Who sues on behalf of the government? How do you draft? All these questions have been properly answered in our parties class Module 3. Do you understand that? So the next thing that we are now looking forward to is what? Motion on notice. Note that when we are talking about an application for summary judgment under the Order 13 of the Lagos rules or Order 11 of the Abuja rules, it must be done by what? By a motion on notice. There is no motion ex parte for summary judgment. It is motion on notice. Do you understand that? Now, brought pursuant to what? Order 13. Order 13. Why? Because it is the specific order in the Lagos rules that spoke about summary judgment. If we're speaking about the Abuja rules, it will be brought pursuant to what? Brought pursuant to Order 11. And then after that, we then talk about the general order for all applications, which is what? Order 43. So brought pursuant to Order 11 and Order 43 if we're in Abuja, but brought pursuant to Order 13 and Order 43 if we are in Lagos. Do you understand? Brought pursuant to Order 13 and Order 43 Rule 1 of the High Court of Lagos Civil Procedure Rules 2019, and most importantly, under the inherent jurisdiction of this court. So there are three things here again. Please cut that. Brought pursuant to Order 13. That's the first thing. And then Order 43 Rule 1. That's the next thing. And under the inherent jurisdiction of this court. I'm teaching you how to draft an application for summary judgment. Right? We have gone through our class for summary judgment. We already know what summary judgment is. We know the rules guiding summary judgment. And now we are asking, how then do we properly draft? How do we properly draft an application for summary judgment? And I'm teaching you, this is how you bring the brought pursuant to clause. Then the next thing, which is the general thing that we say for all interlocutory applications, that is motion on notice and motion ex parte. Take notice that this honorable court will be moved on the dash day of dash 20 dash at the hour of what? 9 o'clock or so soon thereafter, as counsel may be heard on behalf of the claimant applicant, praying this honorable court for the following reliefs, or as counsel on behalf of the claimant applicant may be heard, praying this honorable court for the following reliefs. They are the same thing. We are basically saying the same thing, but certain key things must be there. Number one, take notice that this honorable court will be moved. First thing, you are telling the court, my lord, we won't move you, basically speaking. So take notice that this honorable court will be moved when? On the dash day of dash 20 dash, as at what time? At the hour of 9 o'clock or so soon thereafter. What will happen? As counsel on behalf of the claimant applicant will be heard, praying this honorable court for the following reliefs. So now this is the important part for every interlocutory application. One of the most important part, because we already know how to draft interlocutory application, but there are two key things that people want to see, the markers want to see. Number one, your brought pursuant to. If you are able to remember the order of that brought pursuant to, that is very good, because that's basically what distinguishes one interlocutory application from the other. That brought pursuant to part. If you are able to tell us the general order, which everybody knows, then that specific order for that thing that you are seeking for, if it's an interim or interlocutory injunction, order 42, if it's for summary judgment, order 13 in the Lagos rules, and order 11 in the Abuja rules. If you are able to get that specific order, that is another mark. Because we already have the parties clause. You should know how to draft the parties clause. You should know that it is claimant / applicant. You should know that it's defendant / respondent. Depending on who is bringing the application, it can still be claimant / respondent and defendant / applicant. Right? Depending on who is bringing the application. You know the parties themselves. How do you draft them? You know the court. What is the different thing there? The different thing there, two things. Even the take notice, all the interlocutory application, they all have take notice that this court will be moved. All of them take notice that this honorable court will be moved on the dash day of dash 20 dash at the hour of 9 o'clock or so soon thereafter, as counsel on behalf of the claimant applicant to be heard, praying this honorable court for the following release. Everybody knows that. So what then distinguishes is how you couch your order. This is the seat. An order of this honorable court for summary judgment to be entered in favor of the claimant applicant as per the statement of claim. Do you see that? That is how you draft for summary judgment. You must cram it, you must learn it, because when it comes out, drafting it perfectly like this gives you your 100% mark. Do you understand? When it comes out in exam, drafting it perfectly like this gives you your what? Your 100% mark. An order of this honorable court for summary judgment to be entered in favor of the claimant applicant as per the statement of claim. Do you understand that? And then the omnibus order, like I've always taught you. And for such further order or orders, you can say, and for such, please call that. You can say, and for such further order. It's fine, it goes. You can also say, and for such further order or orders as this honorable court may deem fit to make in the circumstance, right? And then, like I said, for all applications, you must put dated this day. For all application dated this dash day of dash 2019, then you must put your signature part. If you don't put this your signature part, that is minus half mark or 1 mark there for that signature. Your signature, then your name, then your firm, then who you are representing, then your office, then your email address, then your number. You must learn how to follow that order. Name, office, who you are representing, address, email, number. Same thing on notice to. Do you understand? On notice to or for service on, same thing. Right? You can use either of them. Now, Musa Bello. Now, the reason why this is for service on, right? When it is part of the originating process, it is usually for service on. Don't forget that these are the accompanying documents to the originating process for a matter to be set aside for summary judgment. And that is why it's for service on. And in this case, in short, this is a very important thing for us to note. In this case now, we are serving it on the defendant himself, not on the lawyer. When we're talking about interlocutory application, we were serving it on the lawyer. Why? Because the case had already begun. In this case, we are serving it on the defendant himself because we do not know who the defendant's lawyer is yet. You know that the rule is that all originating processes must be served personally. This is one of the accompanying documents to the originating process. Therefore, it should be served personally on the defendant. So another key thing that you want to see in your motion on notice for summary judgment is that you are serving it on the defendant personally. You are not serving it on the defendant's lawyer. But if you are talking about interlocutory applications generally, you usually say on notice to the defendant's lawyer. But this one, we are saying for service on the defendant himself. You usually see on notice to when you are serving it to the defendant lawyer in interlocutory applications, like we saw when we're talking about interim injunction, our draft class for interim injunction, it was on notice to. Do you understand? On notice to. But in this case, the reason why it is not on notice to, but for service on, is because we are serving it on the defendant. Why are we serving it? There are about 8 documents or 7 documents to accompany the originating process, writ of summons, right? When it comes to summary judgment. And the rule is that your writ of summons must be served personally, except you want to then go by substituted means. Do you understand? Which must then be by ex parte order. Do you understand that? But if that ex parte order is not yet there, you must serve personally. So this is one of the documents that you must accompany with that originating process to serve personally on the defendant. Therefore, it is for service on Musa Bello, the defendant/respondent number so and so. If you have his phone number and email address, you can add it. If you don't, you leave it like that. Do you understand that? So I think that we've had a wonderful class speaking on how to draft our summary judgment application under the Abuja rules and the Lagos rules. They are substantially the same. The only thing you put differently is just broad post 1 to 2. That's the only difference. Broad post 1 to order 13 if it is in Lagos and order 11 if it is Abuja. And also, please, the key thing that differentiates all the motions is that order. An order for what? An order for what? You must learn it. An order of this honorable court for summary judgment to be entered in favor of the claimant applicant as per the statement of claim. That is the order you are asking for. Do you understand that? So with that, we end our class for summary judgment application, how to draft summary judgment application. Another thing that we need to look at is how to draft the affidavit for summary judgment application. A key thing we need to look at, and we'll look at it in our next drafting class. Have a very wonderful day.